All right, guys, Levi Trumbull here. We are here today to share with you an update as it relates to State of Maryland versus Shawn Porter. As many of you already know by now, Charlotte Often Brink, the former owner of Dan's Restaurant and Tap House, filed a criminal complaint against Shawn Porter on June 22nd, alleging 5 counts of criminal harassment and 1 criminal count for stalking. If you have not seen the video yet where we break down the application for statement of charges and read that document verbatim, make sure to check that video out. It will get you up to speed on what she alleges against Shawn Porter. So today's update, we have an attorney, a criminal defense attorney who's been practicing criminal defense law for over 30 years in the state of Maryland. Today, I was able to get her comment on this whole situation. She gave it to me off the record. She did not want to be identified, but make no mistake, this, like I said, and I'll repeat it, this individual is a criminal defense attorney in the state of Maryland and has been for over 30 years. She practices law at a 100-year-old law firm in the Baltimore metro area. She appeared on Politically Incorrect with Bill Maher on ABC. She appeared on CNN on a television show called Burden of Proof with Greta Van Susteren, and she was named the Daily Record, which is the Daily Record, for those of you who are unfamiliar, that's a legal newspaper in the state of Maryland. She was at one point named a hotshot on the Maryland Daily Record, and she is also currently a writer of a top cable news channel. She writes articles for a top cable news channel, television news channel. So I had the chance to speak with this attorney, this criminal defense attorney, earlier in the day, and the first thing she wanted to do when I provided her a copy with the application for statement of charges, the first thing that she did, as I did when I broke down the complaint in my previous video on this subject, the first thing that I thought she did was she went right to the 2022 Criminal Statute Handbook and reviewed, just as I did, she reviewed the legal definitions for harassment in the state of Maryland and for stalking in the state of Maryland. So she wanted to first define what it means to harass somebody and what it means to stalk somebody. And one of the first things she did, the first comment she made after she had read the application for statement of charges, and again, I am just reading you notes from our conversation. These are verbatim quotes, essentially, from this attorney. And so here's one of the first things that she shared with me after she had reviewed the documents in the case. One of the first things she had said was that Shawn Porter is what she would refer to as a sharer of information. That's what he does. He shares information. He does that on his YouTube channel. She said that Shawn Porter could claim what is referred to as subsection B of the provisions of the harassment charge when it talks about what harassment is not. She says a lot of what she sees in the complaint, Shawn Porter could raise subsection B under the harassment code, which talks about if somebody is sharing information, it cannot be considered harassment. So she said that Shawn Porter is a sharer of information. That was her quote. Her quote was that Shawn Porter could claim subsection B. Another thing she got into when we were in the complaint, as you guys will recall, Charlotte speaks a lot about makes a lot of references to her father and her sister in the criminal complaint. The lawyer advised me, she said, quote, she cannot speak for her sister or her father. She said she has no legal authority. She also never listed what threats she considers to be a criminal nature that Shawn Porter made against her father or her sister. So again, we'll reiterate that Charlotte cannot speak on behalf of anyone but herself. She said that was hearsay. Another thing that the attorney thought was interesting is that she says in the application, she says, we do not have any indication. It's not listed in the application. There is no indication of when or how Charlotte notified Sean Porter to not come to her home or to not do X, Y, and Z thing. Another issue we talked about, as you will recall in the complaint, one of the things that Charlotte was upset about was the fact that Sean Porter had come near her property. This was a quote. I thought it was a sort of a brilliant quote. She said, this was her quote. She said, "Charlotte cannot issue a no trespass for property not her own. She has no legal power to do such a thing." Again, I just want to say that again. She cannot issue a no trespass for property that is not her own. So what she's saying is that regardless of whether somebody is standing on, a public roadway or not, it's sort of irrelevant to anything. So, and that was one of the things, I guess that's sort of where, from Charlotte's perspective, that's where we see the stalking situation come into play. Another quote the attorney shared with me is when she said that the application for statement of charges does not allege enough specificity. She said, and because of its vagueness, I thought this was interesting, because of its vagueness, and that was the term she used. She said that down the line in the discovery process, Sean Porter's defense attorney should and could request a mirror image of all of Charlotte's communication devices. She said that Charlotte has opened the door for discovery and a mirror image of all her telecommunications devices. So her laptop, her cell phone, her iPad, whatever else, all her communications devices, she has now opened the door for Sean Porter's potential defense attorney to be able to come in and request a carbon copy of those devices, a mirror image of them essentially, so that Sean Porter would have access to all of the data, all of the raw material on Charlotte's devices. This attorney had made the assertion to me that Charlotte, due to her vagueness and due to her statements in this application, has opened the door for that. Another thing, as you recall in the application, Charlotte makes the claim that Sean Porter was harassing her attorneys. Again, the lawyer says that I spoke with today says she cannot speak for her lawyers. And again, we don't know, this was her quote, "We don't know what threats Sean Porter allegedly used." She says there is no specificity. She moves on. She says that in this application that there was a lot of hearsay. She said that Charlotte, and this was another thing, interesting point, could have never come up with this. She not only mentions the fact that Sean Porter is harassing her attorneys, but she makes reference to the Neil Glessner lawsuit and other legal problems that Charlotte is having. This attorney that I spoke with said that Charlotte is opening the door for Sean to get full access of Charlotte's communications with her attorney. Essentially, the attorney said that Sean Porter's defense counsel, she could see them being able to get access to being able to pull private communications between Charlotte and Charlotte's attorneys, essentially being able to pull the whole private case file. Another thing that you'll recall from the application of statement of charges is that Charlotte takes issue with the fact that Sean Porter is posting on YouTube 911 audio that she made. She's also having an issue with the fact that Sean Porter is posting body cam footage on the internet. She said, clearly, this information is public information. The attorney told me that it can be published anywhere. She said, there is no privacy in a 911 call. 911 is a government agency. When you call 911, you waive your expectation of privacy. Another thing that you'll recall from the application of statement of charges, you will remember that Charlotte spoke a lot about feeling unsafe. She personally felt unsafe for herself, for her family. The attorney said that she can't speak for her family. She can't say that, her family feels unsafe. That's not relevant. she can't make that claim because she can't speak for them. She said that when it comes to Charlotte personally feeling unsafe, the lawyer told me that her feeling of being unsafe is irrelevant. There must be what she called an imminent fear of harm. An imminent fear of harm, not from Charlotte's standpoint, but from objective standards. As you recall in the application for statement of charges, Charlotte talks a lot about the fact that Sean Porter is disseminating text messages, communications that she's having with her ex-boyfriend. The lawyer that I spoke with today, she said there is no expectation of privacy when sending text messages. They are considered, she said, if you want to get technical, they are considered property of the phone company, and that when you send a text message, you are disseminating it to somebody else's phone, and when you do that, that person then has the discretion to share it with whomever it is they please. It's sort of like forwarding an email, is how she described it. Another thing that the attorney thought was interesting was she says that she didn't see anywhere in Charlotte's application for statement of charges, she didn't see anywhere where Sean Porter conducted himself in a harmful manner towards Charlotte. She said she didn't see any allegation of harmful conduct. She says the application was extraordinarily vague. When I asked the criminal defense attorney why she thought Charlotte was being so vague, she actually told me that she believed that Charlotte was doing it on purpose for the fact that when you're vague in an application for statement of charges, it can be hard to prove a material fact one way or the other. When you're vague, something is hard to prove. She said, obviously, that's going to be a problem. The way she sees it is that the vagueness is on purpose so that Sean Porter's defense counsel can't come back and be able to definitively prove something wrong. When you're specific, a specific fact can be proven specifically wrong, is what she said. And when you're vague, it makes it harder to do that. I then asked the criminal defense attorney what she thought would happen when the state's attorney's office got in possession of Charlotte's application for statement of charges. She advised me that what they'll do is they will call Charlotte. Perhaps they will call her in. They will ask her for proof to back up her allegations of harassment. They'll see what she has. And from there, they will look at the text messages or whatever else she provides them, and then they will decide whether there was legal harassment with prior notice to stop such legal harassment. One of the things that I thought was profoundly interesting that came up over and over again was the criminal defense attorney had shared this tidbit of information with me, and I would have never thought of it otherwise. She says that Charlotte ruins her own case by saying that Sean is sharing this information online. She keeps showing that Sean is an exception to the harassment law. That's her quote. That Sean Porter is an exception to the harassment law because of the fact he is sharing information with the public. Again, if you go back and you rewatch that video I did where I break down the statement repeatedly, Charlotte is talking about how Sean Porter is putting things on the internet, on YouTube, online in general, and he is doing so in a manner in which is consistent with subsection B of the exceptions of the harassment law. So she says that the criminal defense attorney is telling me that by Charlotte repeatedly admitting over and over again in this application for statement of charges that what Sean is doing is for the purpose of sharing with other people, she, by her very own words, is blowing her own case, ruining her own case and making the case actually for Sean Porter that he is actually not a candidate for harassment charges, that Charlotte Often Brink is herself making the case of why Sean Porter does not fit the criteria for harassment charges. I thought that was profound. The criminal defense attorney goes on. She also reiterates that in this application for statement of charges, there is no blackmail, there's no bribery, there's no extortion. It doesn't, she says there's no allegation that Sean Porter is doing this for his personal benefit, but only to share with other people. I just thought that was fascinating. And lastly, her overall take on the application for statement of charges was she thought that Charlotte was trying to make a claim of defamation in a criminal court. She says that it appears that what Sean Porter is doing, if anything, could potentially be defamation, but criminal courts don't handle defamation. It is a civil matter. So that right there is pretty much where my conversation with the attorney ended. Again, this is a 30-year practicing criminal defense attorney. She was very kind. She was very helpful. She answered a lot of my questions, and she gave me a wonderful insight and professional opinion after she had read the application for statement of charges. I will not predict the future. I will not say where this goes next, but I can tell you we are very early in this process. So again, I want to thank the attorney in question, and I want to thank you guys at home for caring about this issue, for following up with this issue. Obviously, we take matters like this very seriously, and you know, we are going to not be predictors of the future, but we are going to follow it and let the chips fall where they may. So thank you guys very much.